It's 4 o'clock and it's time to get going. Welcome everybody to the Standing Committee on Access to Information, Privacy and Ethics today. We're pursuant to the order of reference of Wednesday, September 27th, 2017, Bill C-58, an act to amend the Access to Information Act and the Privacy Act and to make consequential amendments to other acts. We have with us today, if there's any questions that need to be answered or we have any questions as a committee, at the end, we have from the Department of Justice, Sarah Gay, Director and Counsel General, Treasury Board Secretariat, Ruth Naylor, and we have Riri Shen from the Privy Council Office. Thanks for coming. And I've been asked by each party for a 1-minute opening comment. Go ahead, starting with Mr. Kent.
Well, thank you, Chair. And colleagues may have noticed that the official opposition presented no amendments. And just let me say at the beginning that after hearing the testimony of the Treasury Board President, a myriad of witnesses, and most important, the Commissioner herself, the official opposition has decided that Bill C-58 is beyond redemption. That being said, hope springs eternal. And we will enthusiastically participate in the consideration of amendments. We know the Treasury Board President has indicated he may roll back a couple of the elements which the Information Commissioner has termed regressive. And we look forward to participating. I think finally, it's interesting to note that the bill itself, Bill C-58, is composed of 58 pages of text. The Information Commissioner's condemnation of C-58 amounted to 48 pages of text, and we have before us now amendments taking up 75 pages of text. And I just wanted to make clear that that is the reason that we in the official opposition believe, despite the exercise before us, that C-58 is beyond redemption. The status quo would be preferred.
Next up, MP Rankin.
Well, thank you, Chair. And the objective that the NDP has today is to collaborate in good faith to see if we can improve this legislation. Like my friend, Mr. Kent, there are those who say the bill is beyond redemption, but we are, again, in hope springs eternal, believing we can make a difference. We have proposed 36 amendments. I've been very outspoken in my criticism of this bill because I think it's very important we get it right. I was here 30-some years ago when the bill was initially introduced, lobbying on behalf of reform for the Canadian Bar Association. I was very, very shaken by what our Information Commissioner said about this bill. She specifically testified here that having the status quo would be better than the bill before us. So I can understand the skepticism of my friend, Mr. Kent. However, we're here to try to roll up our sleeves and make it better. And in that spirit, we look forward to the discussions. Thank you, Mr.
Rankin. It couldn't have been 30 years ago. You're so young. Mr. Erskine-Smith, would you like an opportunity? Okay, we'll get right into it. I'd like to start off by suggesting that we'll allow 1 minute per amendment, and we'll start off with, of course, the First Amendment. Clause 1. Clause 1.
Shall Clause 1 carry?
Shall Clause 1 carry as amended?
No, so we're not on an amendment. It's just
okay, we're opening the floor, folks, for debate. Like to vote. Shall Clause 1 carry? All in favor? All opposed? Carried.
Shall Clause 2 carry?
Shall Clause 2 carry? Debate. I don't want to encourage you to talk, but we should just take advantage of this as much as I can. Shall Clause 2 carry? All in favor? All opposed? Carries. So First Amendment, NDP.
Thank you, Chair. The objective of this is to be consistent with the recommendations made by this committee in May of 2016 to extend the coverage of the legislation to deal with the plethora of quasi-autonomous, non-governmental organizations, subsidiary crown corporations, namely those entities for which the government has 50% or more, but are not covered by the existing definition. That is the objective of the amendment before you. I think you'll see that it's consistent with recommendations 1 and 2 of the Ethics Committee recommendations of May of 2016. Chair, I think it's consistent with the principle and scope of C-58 in that this is an amendment to the Access to Information Act. We're simply trying to extend its coverage as this committee has recommended in the past.
So just when we're going to get started here, I'm just going to explain my role a little bit more so you can understand what the chair's role here is in this particular clause by clause. We've had clerks, legislative clerks, give us advice what they deem inadmissible or admissible. So I'm going to put before me what their suggestion is and their ruling is. It's still up to the committee to decide, but I'm going to explain. I'm going to go through that first, then we'll open it up for debate, and we'll go from there.
Oh, it's a ruling, so there's no debate.
It's a ruling.
They can challenge it.
You can challenge it. So maybe explain, just for the committee, just a brief explanation of what I just said.
Yeah, well, basically, there are many rules in terms of procedural admissibility for amendments. The main rules that we use are principle, scope, and the financial prerogative of the Crown. So if an amendment is considered to go beyond the scope of the bill or against its principle, it will be ruled inadmissible. And if an amendment would incur new spending for the government that is not already provided for, it will be ruled inadmissible. Also, when an amendment tries to amend a section of the Parent Act, in that case the Access to Information Act, that is not currently amended by the bill, it is frequently ruled inadmissible because it's beyond the scope of the bill, in fact.
Just a question. When you say frequently, why would it not always be? What's the...
Because sometimes it's the amendment would be consequential to another amendment, or it could be a correction to the existing act that wasn't envisioned in the bill.
Is that clear for everybody? Mr. Rankin?
They might understand there's an interpretation of the amendment that NDP won that's been on. That was just a general statement.
Yes.
Yeah, that was a general statement, but there's a ruling
There is.
prepared for the chair.
For each amendment, yes, there is.
So
I will read it, okay, for this particular amendment. The definition of the government institution in the Access to Information Act is not modified by Bill C-58. The amendment seeks to expand the definition by relaxing the conditions required for corporations to fall under the Act. As House of Commons Procedure and Practice, Second Edition states on page 766, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, the scope of the bill is limited by the current definition of government institution, and I therefore rule the amendment inadmissible.
Well, that is, as expressed by yourself, your opinion as chair, so I'm not able to challenge it, except to say that we're here to amend a statute called the Access to Information Act. It seems to me that key to that statute is the scope of that statute. And so the principle of openness is simply being extended to other agencies controlled by the Government of Canada. So it would seem to me that that should be within the scope of our deliberations. The government chose to bring C-58 in to amend the bill. This is simply in the spirit of that to try to extend it to cover other government institutions. So I would submit that it is within scope, but of course defer to your ruling.
Thank you, Mr. Rankin.
Just a clarification question. So the definition section is being amended. A specific language that is being amended within the definition section. So, I mean, it's only in relation to the specific words that are being redefined that we could move amendments on. That's your interpretation?
Not necessarily. It could be an interpretation given, but in that case, my understanding is that the impact of changing that definition the way it's proposed now would be quite significant. And my advice to the chair was that it would go beyond the scope of the bill. And we have to look at the scope of the bill and not the scope of the act. And I don't think my interpretation is that such a change wasn't envisioned, is not comprised in the scope of the bill itself.
Any other comments? Mr. Bayless?
If I understand, you're saying that this change will expand the scope dramatically, and therefore it's not admissible within the aspects of this particular bill. Is that correct?
Yes. So the procedure will be just to move on to the next amendment and not vote on that one because it's inadmissible. Next amendment. And PV, just so you understand, I don't know if you have the same amendments before you, but the next amendment is been moved by Ms. May.
Thank you, Chair. I'm going to be mindful of time, but I do need to put on the record that I would have the right to put this motion and amendment forward at report stage of the bill before all of Parliament, if not for a motion passed by this committee, identical to the motion passed in all committees, a motion that I continue to protest. It is not an opportunity for me. It reduces my rights, and we have had times where I have clause by clause in different committees at the same time. Very difficult to be in two places at once. Just to put the protest on the record and move quickly to say that the purpose of my amendment, and it's enumerated as parti vert. I think when I first started presenting amendments, people were worried if they said green, it would look like G for government. Parti vert, it's an motion similar to the one put forward by the New Democrats to extend the definition of department to include the minister's office. I have not made the effort to extend it to Prime Minister's office, as that would fall outside the scope of the Act, but I believe this is inside the scope. Thank you.
Debate? See none. All in favor? Mr. Rankin? All opposed? The amendment fails.
So this one just mentioned that it's identical. So
Yeah, and just as an identifier, the motion that had just failed is identical to NDP, the next NDP-2 motion. So there's really no need to vote on that. Any comments?
So now it's
Shall clause 3 carry? All in favor? All in favor? I don't see any. I just saw a few nods, and if you can lift your hands if you're, shall clause 3 carry? Yes? All opposed? Clause 3 carries. Okay, next up, Mr. Rankin.
Yes, thank you. NDP 3 is an amendment that would propose to extend the coverage to the Prime Minister's office and parliamentary entities. The primary thrust of it is Section 3.3 that which would define the Prime Minister's office in the same manner as if it were a government institution. I think this is consistent with the clear promise made by the Liberal Party when they were running for office, and this is simply to give credence to their promise through legislation.
Thank you, Mr. Rankin. So once again, have a ruling. Bill C-58 creates a new Part 2 in the Access to Information Act for specific entities, creating two distinct regimes. The amendment seeks to import into Part 1 entities for which Part 2 is created. As House of Commons Procedure and Practice Second Edition states on page 766, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, having two distinct regimes for distinct entities is a fundamental principle of the bill, and I therefore rule the amendment inadmissible.
Chair, I don't
Rankin.
understand why, if the government chose, why they could have chosen to put this in Part 1, they chose to put it in Part 2, so we get boilerplate, what do they call it, routine disclosure from offices like the Prime Minister's office, not what people might request, not like journalists and others who told us about the sponsorship scandal precisely because they could apply and seek records. Simply putting it in Part 2, therefore, seems to me to be a way of end-running the requirement, and I don't see why it is beyond the scope or principle of the Act to move something from Part 2 to Part 1.
It's not.
So I disagree with respect with the Chair's ruling.
Good.
Oh, I mean, nothing really more to add. So I think it's your ruling.
So just so you know what the procedure is if the ruling of the chair is disagreed with and the ruling of the committee will vote on whether to sustain the ruling of the chair or to support the rule of the chair. Simple majority of committee will decide whether it's sustained again or passed. So if that's what you wish, Mr. Rankin?
That is correct. I would ask for
Okay,
that
so we'll
vote.
go whether you would like to sustain or sustain the chair's ruling. All in favor? All opposed?
So the ruling is sustained.
Yeah. So the ruling is sustained. Thank you. Now shall Clause 4 carry? All opposed? Carries. Now, Mr. Erskine-Smith.
I'll move this, but I frankly, not the most important thing. We did hear some testimony in relation to InfoSource and the importance of keeping InfoSource. This amendment would keep it a digital version of that, given we heard testimony that it's antiquated and the written version is unused. I don't want to place too much emphasis on this. I would move this for debate, frankly. I don't think that this is the solution to access to information necessarily. But given we had it drafted and submitted it, we might as well have a conversation about it.
Okay, we'll open it up for debate then. Mr. Rankin?
I would support the amendment. I think it's the right thing to do. It was shocking that the InfoSource, which has been such a valuable source for so many years to Canadians, was thrown in the garbage can through this bill. To bring it back in a digital form makes eminent sense.
Okay. Agreed. Okay, we'll move to a vote then, if that's all the comments we'd have. All in favor of the amendment? Are you?
Yeah.
Okay, all in favor? All opposed?
It's only InfoSource.
So it's a tie?
No, it's not a tie.
No, it's not tied.
No.
Mr. Deltel doesn't.
Yeah, Mr. Deltel, that's correct. So Mr. Deltel doesn't have a voting, doesn't have a vote on the committee. So thanks, Mr. Deltel. Nice try.
Yeah.
So the amendment fails.
Yeah, I expected this much.
Shall Clause 5 carry?
Shall cause 5 carry. All in favor? All opposed? Clause 5 carries. Second Amendment, Mr. Erskine-Smith.
I won't be moving that one.
Okay.
I prefer my colleagues.
So we have a Liberal amendment. The Liberals who will choose to move that amendment?
No, I'm not.
So it was
I'm not moving
personal
it.
amendments.
Okay.
So we move to it.
Okay, thanks, everybody. NDP, the next amendment, Mr. Rankin.
This is NDP 4, Chair, and the objective of this is to take out the requirements that this bill would impose upon requesters to identify the specific subject matter of their request, the type of record, and the period for which the record pertains. Obviously, as in the words of the Commissioner, one of the most regressive amendments imaginable. Whereas currently, people have the ability to apply for information that they want and in sufficient detail to let an experienced employee identify the record with reasonable effort, and there's a duty to assist the individuals. This amendment, this amendment would take us back to where we've been for the last 30-plus years and take us away from a world where you have to know what you want before you look for it. And I point out once again, Chair, the testimony to this committee by our Information Commissioner, who pointed out that the sponsorship scandal would never have been identified if this section were in place.
Thank you, Mr. Rankin. Debate?
Could I put a question to
Yes.
folks here at the desk? My question, so my colleague, Mr. Saini, has, I think, an important amendment to Section 6.1 that I look forward to supporting. But if 6.1 sub 1 sub A is removed from the Act, that resolves some concern, perhaps, that we've heard. But if that is removed, my question is this. In relation to Section 6, which we're dealing with now, I understand already in the Act it says the request shall be made in writing. And I understand that if it were not to be made in writing, that the department could refuse to process that request. That being the case, what's the difference between that requirement and the requirement shall set out the following information, ABC? And if ABC is not met, isn't the same thing as if an oral request and the department will simply be able to decline it? And if not, maybe you could clear up that ambiguity.
And Mr. Erskine-Smith, who are you asking specifically? Anybody on the group? Okay. Go ahead.
Yes. In fact, we have counsel here today, so if you give me a second, we'll get you an answer for that. I just want to make sure we have the best answer possible for you. Okay? Thank you for your indulgence, Mr. Chair. I think the best answer we can give you is that the duty to assist would require an ATIP coordinator to clarify with the requester to try to get as much information as possible there, and then they'd have an obligation to proceed with the best information they have.
But I understand that to be the case, but if A, B, and C are not met, then they can decline the request.
If the request would be impossible to fulfill. But so there's already policy direction which would pertain in the new world as well, which would say that if you have enough information to fulfill the request, that the request has to be fulfilled.
But correct me if I'm wrong, I'm sorry for this, but that policy guidance doesn't overrule legislation. And so if the legislation specifically says A, B, and C shall be provided, that actually overrides any policy guidance. It has to. And so a department could, in accordance with this legislation, say no to a requester if it doesn't meet A, B, and C, irrespective of anything in 6.1. I just want to make sure, is that correct?
The policy guidance helps an institution interpret the legislation. So that interpretation would still be the case, which is that as long as there is then these pieces of information are requested, as long as there's sufficient detail to enable an experienced employee of the institution to identify the record with a reasonable effort, our policies would say proceed with the request.
If A, B, and C are all provided.
Yeah, to the best of the requester's ability. Yes.
Mr. Rankin?
With great respect, it doesn't say that. It says they shall set out the following three things, and that's the additional change. The policy guidance, which may or may not be the case tomorrow or the day after or 5 years from now, may say something different. We're here to pass legislation. And those are three mandatory requirements, as plain as you can be. And they amend a section that simply says all you need to do is make a request in writing and letting somebody who has control of the record and is an experienced person to identify the record with reasonable effort. That's been how it's been for 30-some years. So this is clearly a regressive step. It requires, it doesn't say may, it requires you to do the three things that are listed, and policy guidance comes and goes.
Mr. Bayless?
If I understand it, and if we take a real-world example, someone makes a the idea behind this change was to make the departments more efficient, and when you look at it, it's very reasonable three things that they're asking for. However, this being said, there might be certain instances where the requester is not able to provide those, and we accept that. If that happens, would it not fall then to the duty to assist, wherein the person receiving this request would say, it's not meeting the criteria, but I have a duty to assist, ergo, I know what the person is looking for. They're looking for such and such a document. I can then inform them, can you write this down on your request? Then I will be able to provide it for you. So would the duty to assist be such that if an incomplete request is there, that the person receiving that request must assist that person requesting to fill in the data? They cannot use it. And as to what my colleague Nathaniel said, it is our intention to remove away the rights to deny that request based if they don't have this full information. So we're going to take that part. If we take that part away in our next step, they cannot use that. The department cannot use the fact that it's incomplete to deny the request.
That's correct. The duty to assist would require the institution to work with the requester to try to fill in any blanks.
And that duty to request is part of the law, right? That will not change.
That is already in the access to information.
That's not going to be an interpretation document that a couple years from now someone could change. That is mandated.
Section 4.2.1, 4 sub 2.1. Yes, it's set out in the law now.
So the concern, the valid concern that Mr. Rankin is raising would not, in fact, play itself out. As he mentioned, the sponsorship scandal could not have been done. But in this case, because of the duty to assist and the fact that they cannot use this incomplete request as a reason to deny it, that they could work its way through the system nonetheless. So all this would actually do is help us be more proficient and effective in other requests.
That's the intent of asking for that information from requesters, and without Section 6.11A, that situation that you're asking about.
If we remove 6.11A,
then that's correct.
I got
Just hold on, Mr.
Yeah.
Ms. May.
Thank you, Mr. Chair. Certainly, looking at the testimony from the Information Commissioner, this section was found to be most objectionable. I'm looking for which Liberal amendment is a government amendment as opposed to a Liberal amendment which is going to be defeated. And perhaps if someone could direct me to which one you believe will modify Section 6 so that we don't have the impact that unless someone actually essentially knows everything about the record for which they're curious before they ask for it, they stand at risk of being denied. You'd have to, and as the Information Commissioner said, records may change from a handwritten form to a digital form and back again. People may not know the exact date. So I just do want some clarification before dispensing with, and my amendment will fall in the same category. Which amendment is essentially now a government amendment attempting to fix this problem?
You want to respond, Mr. Erskine-Smith? You're next on the order, or would Mr. Bayless like to respond? That's up to you.
That's a valid question, because what the government is hoping to amend, the next amendment coming up is 6.11A, I believe. You have it there. Can I see it? Where there was, in what was originally put forth, the opportunity to deny this request if it wasn't complete.
Exactly.
But that's going to be, it is our intention in the next step to remove that ability to use it as a denial. So that if we didn't remove that, then the concerns that Mr. Rankin brought up would be valid, because it could be used as an opportunity to deny the request. Now, it cannot be used as an opportunity to, if we make this change coming up next, then it cannot be used as a way of denying the request.
Go ahead. Do you want to respond, Ms. May? Because you asked a question.
I just want to clarify, which amendment is it that you believe does that?
The next amendment that we're going to propose, it's coming up Liberal. It's Liberal 3.
Okay.
Okay, so
Okay,
we move through, okay.
Okay, Mr. Erskine-Smith.
Yeah, so I think Frank raises a really good point about refusal. So I just want to work through this. So if we amend 6.1, as my colleague Mr. Saini has an amendment, Lib 3, that will remove 6.1 sub 1 sub A, and it would give the Information Commissioner the authority to grant departments the ability to refuse, which is an additional protection. But that authority doesn't relate to Section 6 at all. And so my understanding, but correct me if I'm wrong, if someone doesn't make a request in writing, that request doesn't need to be fulfilled. Is that right? And if that's the case, what's the difference between that requirement and the requirement for A, B, C? Why is one sufficient to refuse a request and the other is not, based on how this legislation is drafted?
The best answer I can give you to that is that the need to receive a request in writing is necessary administratively for the system to operate. If the requester provides A, B, and C to the best of their ability, an institution is going to be required to respond to that request.
Required by policy advice or by legislation?
Required by policy advice in addition to what we see set out here. So there are supporting documents that give direction to institutions on how to apply the Act.
And the next government changes that policy advice and this legislation stands, and an individual can have their request rejected if they don't meet A, B, and C as this legislation is written.
Mr. Kent.
Yeah, no, I'd just like to refer again to the commissioner herself, who said that these requirements, as Mr. Rankin pointed out, and again, given to the judgment of the day, it doesn't matter what intention may be intended, but the commissioner herself said these three conditions would have blocked Canadians' knowledge of the sponsorship scandal. And I think if the amendment to assist is certainly a worthy one, but these three, A, B, and C, could also be removed if that intention is as the government claims.
Mr. Bayless.
To the point of Mr. Kent, 6.11A stated, and this is the document, and the Information Commissioner is correct as it was presented, because it states very clearly the request does not meet the requirements set out in Section 6. It can be used to deny access, and that's stated very clearly. That being the case, our government agrees with the Information Commissioner is going to remove that 6.1.1A so that it cannot be used to deny access. So we intend to balance efficacy by asking for this information. Nonetheless, if it's not provided, it cannot be used to deny access. And the legal right and requirement duty to assist would be such that even an incomplete 6 would be assisted in being complete to move forward.
Mr. Rankin.
I think it is positive that the government is prepared to delete this odious section that requires people that allows the government to reject requests simply because they haven't put the specific subject matter, the type, or the period together. So I think that is progress. But, you know, this notion that somehow we can be happy that there's a duty to assist, I would point out the remedy is a little bit indirect. If there's a person who is a public servant who doesn't make every reasonable effort to assist the person with the request, etc., the remedy is probably a disciplinary matter. I suspect it would be something indirect like that. Meanwhile, people aren't getting the records that they requested, and information delayed is information denied. So looking at that as the hook to say everything's fine now, I don't understand. Secondly, these things that you are now requiring to do, identify the subject matter, the type of record, and the period, are obviously to assist the public servant in discharging his or her responsibility to identify the record. But the section that's going to remain, 6.1, deals with the problem of large volumes or frivolous or vexatious requests or people who've already been given the record. So by keeping those things there, it's hard for me to understand why you need to still have the things in A, B, and C that only puts an obstacle in front of the right to know. It adds nothing except an obstacle for reasons that I do not understand.
Mr. Bayless.
2 points to Mr. Rankin's point. If you have an incompetent bureaucrat, they may be incompetent, quite frankly, in duty to assist. They may have all the information and be incompetent in finding the information. So I don't think trying to criticize a bill because the person that's going to implement it might be incompetent. They could be incompetent in any number of ways, and that's not our role here. Our role is to write proper bills, and with the assumption that the bureaucracy is competent. So your argument there does not hold water. Second point, the request for this information, we heard also very clearly that timeliness is important. We heard time and time again that speed of answering a request is important. Now, what's being asked for in Section 6, which is not mandatory in terms of being able to use to deny requests, specify the subject matter. So what are you looking for? What's the subject matter? The record you're looking for? And the period. These are three simplistic things. Now, if you're not able to provide that, you'll be, through the duty of assisted to provide that. So you could say, well, the guy helping may not be that good at helping. Okay. The guy looking may not be that good at looking. There's any number of reasons that bureaucracy may not work properly, but that's not how you address a bill or not.
Mr. Rankin.
You're the one, with respect, who said that we should look to the duty of assistance by public servants to backstop this regressive measure. A regressive measure as described not by me but by the Commissioner. And the duty to assist is as good as the individual who is there. That individual may consistently thwart requests. I don't know, but all I know is the remedy will be so long in the disciplinary process that the Globe and Mail who sought that article will be, the reporter may have moved on long after that. So I don't accept that. And secondly, to suggest it's no big deal to say the type of record being requested and the period being requested, it is a very, very big deal because you don't know. You don't know, and that's the point the Commissioner made so powerfully before this very committee. And you're supposed to rely on the good faith of some junior official in some department who may not want government rec to be embarrassed by the disclosure of records showing spending or maladministration. That's the whole point of this bill. It's not to make things easy for the government. It's to give citizens what the courts have described as a quasi-constitutional right to know in our democracy. All this does, with great respect, is put obstacles in the way that are totally unnecessary and, in the words of our Commissioner, regressive.
Ms. May, 1 minute.
I appreciate the latitude, Mr. Chair, because my amendments speak to this very issue. And the reason I asked earlier to be directed to the amendment from the government that attempted to solve the problem that was presented in Clause 6 and identified so forcefully by many witnesses, including the Information Commissioner, is that Lib 3 does not do what I believe the Liberals think it's going to do. If you read Section 6 by itself and you imagine statutory interpretation, you have mandatory requirements at several places. The request shall be made in writing. and shall set forth the following information and provide sufficient detail. There's a lot of requirements there. I don't believe that a government department will feel confident that it has to go to the Information Commissioner to get permission in order to say, we've read the provision. We don't have to answer this request. It's very clear, black and white, that request for an access to record, the person requesting it, shall do the following things mandatorily. The section that follows, 6.1, which is the only section being amended at this point, and I hope you'll consider my amendments, but 6.1 creates a discretionary opportunity that the head of a government institution may, before giving person access to record or refusing to do so. So before refusing to do so, the requirement of a head of government is discretionary. They may decide for these reasons. There's absolute requirements that the person asking for the record under Section 6 is required to have it in writing, is required to speak to A, B, and C, and provide sufficient detail. Those are mandatory requirements of this Act that I don't believe are obviated by the amendment put forward in Lib 3. And I think there's good intention here, so I hope perhaps we can work together and fix it.
Smith.
I just had one other question, and it's if 6.1 sub 1 sub A were to stay in the Act and the Information Commissioner were to have that discretionary authority to deny government institutions the ability to refuse, wouldn't that actually create more protection than deleting Section 6.1 sub 1 sub A and leaving 6 as is? Because at least then we're giving the Information Commissioner the authority to determine whether refusal can be granted. Whereas right now, removing Section 6.1 sub 1 sub A and leaving 6 ABC, Information Commissioner has nothing to say to it. But I could be wrong. That would be my my legal interpretation.
Are you asking somebody specific?
Yeah, I'd be curious.
So just to clarify, the requester has a right to complain to the Information Commissioner now under the current Section 6 if they feel that an institution is not responding to their request inappropriately. So a complaint could be made. And similarly, in the future, if the Act is amended as proposed here, if an individual felt that an institution wasn't fairly making a determination about how to respond to their request, they have a right to complain to the Information Commissioner. So the Information Commissioner would have oversight over any decisions here. So just to give an example, type of record requested, typically what an institution's looking for there is, do you want all emails or do you just want briefing notes? Sort of what are you looking for, only the paper records we have, or do you want us to search our emails? They're looking for enough information to provide that requester with what they need. Now, if someone's unable to respond to that and the duty to assist doesn't resolve that, and there's a sense from the part of the requester that they're not getting the service that they should be getting, they have an ability to make a complaint to the Commissioner.
I guess what I was trying to drive at is if we remove 6.1 sub 1 sub A, the department can refuse if ABC is not provided. You're saying they won't, but under the legislation they appear to be able to. Whereas if we were to keep 6.1 sub 1 sub A and add that the Information Commissioner has the discretion to grant the ability to refuse, that seems more protection. But again, maybe I'm wrong.
I won't speak to what's more protection up, but I would say that I agree with you that that would be the effect of keeping both in. And you're talking about a situation where the Information Commissioner must approve the use of 6.1.
Okay,
sub
I
1.
think I understand. Thanks very much.
Thank you.
All right. Any more debate? So again, we're talking about NDP motion 4. All in favor? All opposed? I believe it's...
45.
Yeah, I believe it's defeated.
So PV2 was identical.
And just for reference, we've used PV2 as Ms. May's prefix on her motions. It's identical to the MVP motion that we just defeated, so therefore it's defeated. Liberal 3, Mr. Saini.
Just want to make sure that, that the departments will have a very narrow power to decline a request to release information. And I think this may answer some of the questions that have already been discussed.
That's it? Do you want to
Yeah.
speak to it? Okay. Debate?
To mention this.
Okay, if adopted to NDP 5, NDP 6, PV 3, and PV 4 cannot be moved. It's line conflict. Okay, so all in favor? All opposed? Liberal 3 carries. So we're going to go all the way down to Liberal number 4. Mr. Erskine-Smith.
This is to amend 6.1 sub 1 sub B. There was some concern about the specific language used as to whether someone had already been received the record, and we went back and the Information Commissioner had actually proposed different language in a previous report, and that's the language that I've used.
Any debate? All in favor? All opposed? Carries. So move on to PV 5. PV 5 cannot be?
No.
So that, sorry,
Wait,
after,
wait, oh, yes, it can be moved.
it can be moved? Sorry, just getting clarity here.
Sorry.
Sorry.
So,
Okay, so PV 5, Ms. May.
So this is based on the recommendation, again, from the Information Commissioner that that we delete the lines 26 to 31 that deal with records that were frivolous or a large number of records, and that would be unreasonable. And per the Information Commissioner's recommendation, this amendment is very straightforward. It deletes the lines that include from the request is for such a large number of records that necessitates a search of such a large number, acting on the request would unreasonably interfere, and so on. Thank you.
Debate? See no debate. All in favor? All opposed? It's defeated. Shall Clause 6 carry as amended?
oh, right, there's the 4.1.
Oh, sorry, Lib 4.1, just Mr. Saini? Okay.
Okay, so that Bill C-58 in Clause 6 be amended by adding after line 34 on page 3 of the following. The head of a government institution is not authorized under paragraph 1B to decline to act on a person's request for record for the sole reason that the information contained in it has been published under Part 2. That's exactly here.
Is any more to say, Mr. Saini? Okay, we've all seen the amendment. We've received it before the meeting. Debate. All in favor? All opposed? Carries. Shall Clause 6 carry? Go ahead, Mr. Smith.
Just so Ms. May had an amendment to delete 6.1 sub 1 sub C, and I understand the reasons for doing so, but in some cases it may slow the machinery of government down unduly to and I think refusal should be granted. My only concern is that there's no balance between the large number of records and the fact that it would undermine government operations and the public interest. And I think, you know, I don't expect this to pass, but I would put it for debate. I would move that we add 6.1 sub 3 to read, in exercising discretion pursuant to 6.1 sub 1 sub A, the Information Commissioner shall balance the reasons for non-disclosure against the public interest in the disclosure of any records.
I will need to add that in writing.
Yep. And again, this is only because I think that Ms. May raised a real concern, and it's worth discussing if that's a possible solution. I'm putting it on the floor now, so I don't expect it to pass, but it's worth talking about.
Okay, so for the sake of the committee, Mr. Erskine-Smith, do you mind repeating that just a little slower so we can all...
You've got...
We've got your copy?
Yeah, you got my
So we
copy.
can read it then, here. Okay, so I'll read out the amendment by Mr. Erskine-Smith. 6.13, in exercising discretion pursuant to 6.11A.
Sorry, it should be 6.1 sub 1, not sub A.
Clear as mud.
Yeah, no, but it's in relation to if we've deleted A, so it's B, C, D that remain. It'll now be A, B, C, but it's all reasons for refusal. So 6.1 sub 1. So remove A in my.
Okay, so let's do this again. Hopefully I've got it right this time. Potential amendment 6.13, in exercising discretion pursuant to 6.1 sub 1. The Information Commissioner shall balance the reasons for non-disclosure against the public interest in the disclosure of any records. I can repeat that again if you need. Okay, in exercising discretion, sorry, I'll start completely from the beginning. 6.1 sub 3, in exercising discretion pursuant to 6.1 sub 1, the Information Commissioner shall balance the reasons for non-disclosure against the public interest in the disclosure of any records. Yes, Mr. Bayless.
I was just going to ask, can you explain that?
Yeah, sure.
So I could understand it?
Sure.
Yeah, go
So
ahead.
the purpose of this, and Ms. May's one solution was to delete the requests for such a large number of records. But if we're going to give the Information Commissioner discretion over this section, that's a great thing, and I think it's a really important amendment that Mr. Saini moved. But the only concern that I would have with with what was 6.1 sub 1 sub C is that we're allowing for requests to be denied where there's a large number of records that would unreasonably interfere with the operations of government institutions. And I think we ought to put in writing that it's incumbent on the Information Commissioner in doing a balancing act between what would interfere with government operations, that the public interest should be considered as well for that and for any other decision to refuse.
Open it up for debate.
Honestly.
I think it's a very helpful suggestion. I support it.
Mr. Rankin supports. All right. So now this is the amendment we're voting on. All in favor? All opposed?
Were we voting? Because that's something I haven't thought about. Could we
How long
take
of a
couple
break are you suggesting? A minute
3
or
minutes?
two?
2 minutes, just so I can understand it?
I'll give you 2 minutes.
Thank you.
Meeting back to order. So, Mr. Bayless, you said you were ready?
He's disappeared. You've lost quorum.
Just a note to the committee, when I say 2 minutes, I actually mean 2 minutes, so I'll be more disinclined to give breaks again if the people say they're ready and they're not. So just a little warning there. We'll proceed to the vote. So voting on Mr. Bayless.
Before I proceed to a vote, after having this break, I just want to explain, I'm going to vote against this because it's my understanding this will actually curtail the latitude of the Information Commissioner by being specific on what she must take into account, where she presently can take that and anything else she so chooses to take into account. So I'll be voting against it for that reason.
Okay, Mr. Rankin.
Just because there's a statement that she must take X into account does not mean she cannot take Y and Z into account.
Any more debate? We'll move to the vote. All in favor of the amendment? All in favor? All opposed? The amendment fails.
Clause 6 as amended.
Shall Clause 6 carry as amended? All in favor? All opposed? Motion carries. Mr. Rankin, NDP 7.
Thanks, Chair. This is a really simple one. It would simply, Section 11 of the Act is the section that requires people to pay a fee, a toll gate on the public's right to know of $5, a toll gate fee that costs the government by testimony $55 if it's a check to process. So while it seems bizarre in terms of the economics, it also should be seen as an obstacle that doesn't exist in most provincial freedom of information laws. The amount of recovery is minuscule in the grand scheme of things, and all it can be is yet another obstacle to the people's right to know. I point out that recommendation 14 of this committee was entirely consistent with removing the fees. I'm just proposing this in order to implement this committee's own recommendation.
So just for the committee, another ruling from the chair. Bill C-58 makes adjustments to Section 11 of the Access to Information Act, which deals with fees. The amendment seeks to repeal Section 11 of the Act. As House of Commons Procedure and Practice, second edition states on page 766, an amendment to a bill that was referred to in committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, Bill C-58 allows for modifications of fees provisions of the Act, but the scope and the principle of the bill doesn't go as far as to allow for a complete elimination of fees. I therefore rule the amendment inadmissible.
If it was 25 cents, that'd be okay.
Yeah. So in other words, if the government had chosen to say the fee is reduced from A to B or expanded from A to B, that would be fine. But because they chose to be silent on something that has for 30 years been seen as an obstacle, it's not within the scope and principle of an Access to Information Act. I find that hard to believe.
So would you like to challenge the chair, Mr. Rankin? Okay. So we have another challenge to the ruling. Rule to sustain the position of... So the question is, shall the decision of the chair be sustained? All in favor? All opposed? The ruling stands. So we have Ms. May Go ahead.
Thank you, Mr. Chair. I don't find your ruling hard to believe because that's why I proposed this amendment instead of the other one, because I would love to eliminate all fees, but I was anticipating the ruling that you just made. So I've only suggested removing the additional payment subclause of 11 sub 1, and essentially eliminating 11 sub 2. I'd remind my friends on the other side of the aisle that the Liberal Party platform says we will make it easier for Canadians to access information by eliminating all fees except for the initial $5 filing fee. And even more wonderful from our historical archives is a private member's bill from 2014, C-613. It was put forward by the member from Papineau, and in it he said in his speech at the time, the Act, his private member's bill, would require that only the initial $5 request be paid by Canadians with no additional fees added later on. So we have the member from Papineau's private member's bill, the pledge from the Liberal platform. It seems to me that sub 2 of clause 11 is in here in error, and the effect of my amendment would be to get rid of it.
Thank you, Ms. May. Debate? All in favor of Ms. May's motion? All opposed?
Getting closer.
Amendment fails. And we'll move on to Ms. May, number 7.
And not to take a lot of time of the committee, this has the same effect. My Parti Vert 7 has the same effect as Parti Vert 6 in eliminating the additional fees after $5.
Okay, so put it up for debate again. Seeing no debate, all in favor of the motion? All opposed? Motion's defeated. Shall clause 7 carry as amended? Or no amendment, sorry. Shall clause 7 carry? All opposed? Clause 7 carries. Thank you. Shall clause 8 carry? All in favor? All opposed? Clause 8 carries. NDP 8, Mr. Rankin.
Thanks, Chair. So in every Access to Information Act, there is a statement of the public's right to know. Then there are exceptions to that rule that should be narrow, and then there is an independent umpire who decides whether the records should be disclosed if the government doesn't want to disclose them. This next set of amendments, in particular NDP 8 to start, is about that exemption. And the exemptions, the Commissioner has said over and over again, as have other witnesses, and in many statutes across the land, they have what are called harms tests. Rather than simply a category of information that can be withheld, whether there's a harm or not, the objective in my amendment is to add a phrase that would say the disclosure of the information would be injurious to a particular interest. Now, I realize that the threshold question for you, Chair, is whether or not these amendments, as the others that I've proposed, are within scope. And I of course, will respect your ruling on this. But I point out that this is consistent with what, for 20-some years, has been suggested by committees like this, that there be changes to these exemptions. This is how you swallow the rule. This is how you swallow the rule of openness. You just have to make the exemptions broad enough that everything gets withheld. And so this is an effort to do what many commissioners have sought and which most legislation across the land does, which is provide a harms test rather than simply a black hole into which the government can pour whatever they don't want disclosed.
Thank you, Mr. Rankin. Again, a ruling from the chair. The amendment seeks to amend a section of the Access to Information Act that is not amended by Bill C-58. As House of Commons Procedure and Practice Second Edition states on pages 766 and 767, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act, unless the latter is specifically amended by the clause of the bill. It is therefore the opinion of the chair that the amendment and consequential amendments NDP 32, 34, and 37 are inadmissible.
That is consistent Chair,
Yes.
with your earlier rulings.
I like it, Mr. Rankin, but it's just I have a job to do. So we'll move on. NDP 9.
Oh, very narrow one. I'm not sure if it's going to be ruled in order in light of what you've just said, but it would simply say, whereas currently the Act says that you can withhold information on strategy or tactics adopted by the Government of Canada relating to the conduct of federal-provincial affairs, this would simply narrow it to say federal-provincial negotiations. In a federation, to give you an example of what I just said before, there are certainly a lot of things that have to do with federal-provincial affairs. So you see why this can be abused. That's why so many commissioners have asked it to be narrowed. This would merely affect those things where there are negotiations, and fair enough, there should be an exemption I would submit for that. But this is an example where the exception can swallow the rule, and I was hoping that this committee would be consistent with its predecessors and try to improve it for Canadians.
Thank you, Mr. Rankin, once again. For the same reason, do you want me to repeat it every time? The reason why not? Anyway, I'll say it again. As the House of Commons Procedure and Practice, second edition, states on pages 766, 767, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or section of the parent act, unless the latter is specifically amended by the clause of the bill. It is therefore the opinion of the chair that the amendment is inadmissible.
I'm seeing a pattern develop here, Chair. I don't know if it's just me, but
I'm in
maybe it's just an
opposition too,
echo in
Mr.
the room.
Rankin,
I don't
so
know.
There you go.
Well, this
you.
is just another attempt in number 10 to
Go
add
ahead.
an exception to provide for a requirement that the head of the CBC may refuse to disclose records requested that contains information, the disclosure of which could reasonably be expected to be injurious to the integrity or independence of the institution's news gathering or programming activities. And that would be the reason for it. I assume that you're going to rule it out of order as with the others.
That is a correct assumption, Mr. Rankin. So do you want me to read out the reason, or is it's the same reason as we had before? So I'm assuming we want to keep moving. So it is ruled inadmissible, Mr. Rankin. So NDP 11 next.
I'm feeling this may not go over very well either, Chair, but this is an exception that I would ask that Section 17 of the Access to Information Act be replaced by the following. First part is the same, but you'll see the second part. The head of a government institution may refuse to disclose any record requested under this part that contains information the disclosure of which could reasonably be expected, now here's what we would add, to threaten the safety or mental or physical health of individuals, or that could reasonably be expected to increase the risk of extinction of an endangered species or increase the risk of damage to a sensitive ecological or historic site. I could point out that there's a section to that effect in the BC Freedom of Information and Protection of Privacy Act, and it gives great comfort to Indigenous Canadians that such a section is there. This act is silent. It's something that's been called for a long time.
And Mr. Rankin, too, again, it's inadmissible based on the Parent Act principle as mentioned before. So NDP 12.
I assume that it'll suffer the same cruel fate, Mr. Chair, that the others have felt. This is simply an effort to use the common law definition of trade secrets and take out Section 18 sub A, which has a lot of other reasons to withhold information, which we think are unnecessary in light of the common law understanding of what a trade secret is. In other words, this is another way in an effort to provide more information to narrow the category of what can be withheld.
Once again, it's ruled inadmissible based on the Parent Act principle as mentioned before.
Right.
So we'll move on. Shall Clause 9 carry? Yeah, that's correct. Yeah, it's shall Clause 9 carry? All in favor? All opposed? Clause 9 carries. New clause 9.1 NDP, Mr. Rankin.
This is 13.
Yes, it
DP
is.
13, yes. This is another effort to narrow the material that can be withheld. Says the head shall not refuse to disclose a record. If that record contains, we would add details of a contract or bid for a contract with a government institution. There's been lots of case law suggesting this part of the bill has been, over the years, abused. This is an effort to provide ability to get public's hands on the details of contracts or bids of contracts to make it clear that they're available, notwithstanding the general exception to the rule.
Again, for the same reasons as mentioned before, it's ruled inadmissible based on the Parent Act principle. Mr. Rankin.
I suspect NDP 14 will be likewise ruled inadmissible. It would deal with one of the most contentious and abused sections of every Access to Information Act across the land, which is the policy advice exception. And things that are, records that are less than 5 years old can be withheld if they are advice to government. You can imagine how many records would fall into that category. So what we've tried to do in this is add harms test to each of the categories to ensure that it's not abused. And only when the government can show a harm would they be able to hide behind policy advice. And then we add a long list of material that would be still available, factual reports, statistical surveys, environmental impact statements that nevertheless would be disclosable even if they might be deemed policy advice. Again, something that this committee has long sought for.
Once again, that particular amendment is deemed inadmissible with the Parent Principle or the Parent Act principle, so it will move on to NDP 15.
Yes, this may be another example. It's only a couple left, Chair, where we've tried to narrow the categories. The legislation adds reference C-58 to disclosure where solicitor-client privilege is involved. And this would be confirming that the Commissioner has the ability to deal with matters of solicitor-client privilege, but also would add that the disclosure only withheld if the disclosure of the information could reasonably be expected to be injurious to the interests of the Crown. There's a phrase that lawyers use called lawyer washing, where you simply bring a lawyer into a meeting, call it solicitor-client, and that's the end of access. This is to say, yes, it's solicitor-client, perhaps on its face, but if it's only whether it's injurious to a demonstrated interest of the Crown, that the information would be withheld. But I realize it's another effort to narrow the exemptions, and you consider that in your judgment to be contrary to the scope and principles of the Act.
This one is deemed admissible, so it's open for debate.
Whoa! Well, let me start again. It's consistent with all the other efforts I've made to make sure that there's an injury test, and I'm just hoping that people will see fit to amend it accordingly, because otherwise, as I said earlier, lawyer laundering is a well-known fate in this country. Bring a lawyer to a meeting, call it solicitor-client, and close the door.
Debate. Any further debate? We'll call the vote. All in favor of the amendment? All opposed? The amendment is defeated. Shall Clause 10 carry? All in favor? All opposed? Okay, Clause 10 carries. NDP 16, Mr. Rankin.
Okay, I got sort of lucky that time. Hopefully I'll get a little luckier this time. Section 24 of the Act consists of a schedule of a lot of other acts that have non-disclosure clauses. Way back in the early 90s, it was recommended that this section be repealed because it's the interest protected by that list of acts is actually protected elsewhere in the exceptions. I note that this Schedule 2 is growing. In 1983, there were 40 provisions in 33 statutes. Today, as of 2014, there were 81 of these provisions in 58 statutes. So much for the right to know. I'm hoping that this committee will go along with the Information Commissioner's recommendation in this regard and fix this problem.
Mr. Rankin, another ruling from the chair with legal advice. Bill C-58 removes a moot subsection from Section 24 of the Access to Information Act. The amendment seeks to repeal Section 24 of the Act. As House of Commons Procedure and Practice Second Edition states on page 766, an amendment to a bill was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. In the opinion of the chair, because of the very technical modification it makes to Section 24, the scope and principle of the bill doesn't allow for a complete elimination of the section. I therefore rule the amendment inadmissible. So we'll move on. Shall Clause 11 carry? All in favor? All opposed? Clause 11 carries. NDP 17.
I believe NDP 17 is consistent with the Information Commissioner's recommendation, and the amendment is simply would say that if under subsection 1, a part of a record is, for the purpose of being disclosed, severed from something that's otherwise subject to solicitor-client privilege, the remaining part of that record continues to be subject to the privilege. It's an amendment to the Section 25.
Thank you, Mr. Rankin. Unfortunately, again, it's inadmissible based on the Parent Act principle.
The good news is, Chair, that number 18 I can withdraw because it's essentially duplicative of the other one.
Okay, so NDP 18 has been withdrawn,
Yes.
and so we'll move on to NDP 19. Mr. Rankin.
This is relatively straightforward. Section 26, we would suggest be replaced by the following: whereas currently there is a 90-day requirement, if an institution believes that material is going to be published by the government currently it says within 90 days, then they can withhold it. But we're suggesting that that be limited or reduced to 60 days. And Section 26.1 would say if the Information Commission recommends after an investigation, the head may disregard an access request that's contrary to the purposes. Again, something recommended by our Information Commissioner.
Again, Mr. Rankin, that amendment 19 is ruled inadmissible based on the Parent Act rule. So we have another amendment, Mr. Erskine-Smith, or is it Mr. Bayless? Okay, go ahead.
So have an amendment, 11.1, Section 26 of the Act is replaced by the following. The head of a government institution may refuse to disclose any record requested under this part or any part of a record if the head of the institution believes on a reasonable grounds that the material in the record or in part of the record will be published by a government institution, agent of the Government of Canada or Minister of the Crown, other than under Part 2, within 90 days after the request is made, or within any further period of time that may be necessary for printing or translating the material for the purpose of printing it.
Thank you, Mr. Bayless. Debate?
Through you, Chair,
Mr.
just to understand what this does that's different than the current Section 26, what is the effect of this change? Is it just to reference Part 2 now? Is it just a technical amendment, or is there substantive change intended?
We have a question, Mr. Bayless?
No. Show me the 26. And what is it exactly that we're doing for? So we're clarifying.
Go ahead.
It's a clarification that would be such that in the event that the government could not use this to, if there is an ATIP for under Part 1, the government could not use this section to not publish information. So it's a clarification on that aspect of it. Could not use Part 2 to stop something in Part 1.
Mr. Rankin, that's good? Any further debate on the amendment? Okay, we'll vote on the amendment. All in favor? All opposed? Amendment carries. We now have...
Clause 12.
Okay. Shall Clause 12 carry as amended? All in favor? Yeah, my apologies, folks. Shall Clause 12 carry? All in favor? All opposed? Clause 12 carries. Thank you. NDP 20.
Oh, there's something before.
Sorry, just... Okay, there is another Mr. Erskine-Smith.
Where is it?
I don't have it. You.
Okay. Mr. Dubois.
Yeah.
Go ahead.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. That Bill C-58 in Clause 13 be amended by deleting lines 23 to 25 on page 5, please.
Okay, Mr. Rankin.
What is the effect proposed by this? It's a consequential amendment to what we just did. So it's a technical amendment? Yes.
Any further debate? All in favor of the amendment? All opposed? The amendment carries. Now we'll move on to NDP 20. Mr. Rankin.
This amendment is an effort to, again, give effect to the Information Commissioner's recommendations that she shall receive and investigate complaints, and shall be the one who decides that an access request should be disregarded as being contrary to the purposes of this part. So it would give the power to the Information Commissioner to refuse, not the government institutions. That was the objective.
Thank you, Mr. Rankin. Debate? Seeing no debate, all in favor? All opposed? It's defeated. PV8, Ms. May.
Thanks, Mr. Chair. This is, again, based on the testimony from the Information Commissioner. And I just want to say parenthetically, I've never seen testimony so strong from any officer of Parliament on any bill that was within their area of competency as the complete and very clear evidence of Suzanne Legault as Information Commissioner that this bill takes us backwards. And one of the areas that she marked in her submission as regression was the section that engages the Privacy Commissioner in investigations. So I know you'll remember her evidence that this is creating an unnecessary procedural burden to the Information Commissioner's investigations, that it is unnecessary and duplicative and burdensome. What my amendment proposes to do, which you'll find as partie vers 8, so on page 6, what it does, bless you, is it takes out lines 20 to 22 to remove any implication of the Privacy Commissioner in the decision under sub 5 under notice to clause 12.
Thank you, Ms. May. I'll just make a note. Consequential to PV 11, vote on PV 8 will apply to PV 11 and other consequential amendments, PV 9, PV 17, and PV 18. Also identical to NDP 21, NDP 21 and related amendments, NDP 23, 25, 35, and 36, and cannot be moved after vote on PV 8. If that makes sense. Trust it does. We're getting right down to the wire, folks, for time, so it'd be nice to get one. We have a couple more just to go through, if we can get that done before we rise, but we'll do this quickly. Any debate? Seeing no debate, all in favor of the motion? All opposed? Motion's defeated. So we have one more before.
So this one is dealt with.
Okay.
So it's
NDP 21 is already negatived, so shall clause 13 carry?
as amended.
As amended.
Sorry, I just didn't understand what you said there, Chair. Are you saying that NDP 21 is out of order? Oh, I see.
Yeah, the only reason, yeah, Mr. Rankin, it was identical, Ms. Mays, to yours, so that's why it's already defeated. Shall clause 13 carry as amended? All in favor? All in favor? All opposed? Clause 13 carries, and with that, we are at 5:28, and we will carry on next time. Thank you to folks down at the end there for helping us out today, and we'll see you Wednesday. Meeting's adjourned.